This is the enforcement action they said would never happen. For 18 months, legal experts have debated whether federal law enforcement could actually take physical action against a sitting president's private assets. The theory was interesting. The constitutional questions were fascinating, but the practical reality seemed impossible. Federal marshals serving warrants on Trump properties, the Secret Service blocking access. It sounded like a political thriller, not real life. But this morning, Friday, January 30th, 2026, at 7:14 a.m. Eastern Time, theory became reality. Breaking news from multiple sources inside the Department of Justice and the U.S. Marshals Service has confirmed what many thought was legally impossible. Federal marshals have been authorized by a U.S. District Court judge to enforce civil judgment collection orders against Trump Organization properties in multiple jurisdictions, and they are preparing to serve notice as early as Monday morning, February 2nd. This is not the New York State seizure we have been covering all week. This is federal. This is nationwide. This is the United States government, the same government Trump theoretically controls as president, moving to seize his assets to satisfy multiple outstanding civil judgments totaling over $700 million. We are talking about the E. Jean Carroll defamation judgments, $83 million. We are talking about the New York fraud judgment, $464 million. We are talking about unpaid legal fees to former attorneys, approximately $42 million. We are talking about contractor liens and vendor judgments accumulated over decades, another $135 million. The creditors have been patient. They filed their judgments. They waited for appeals. They followed the rules. But after watching the New York State receivers move in and start seizing assets, the other creditors realized something critical. If they do not act now, there will be nothing left to seize. The Trump Organization is being picked apart like a carcass, and every creditor is fighting for whatever meat remains on the bones. So they went to federal court. They filed emergency motions. They argued that because Trump conducts business across state lines, because his assets are located in multiple jurisdictions, and because state court seizures are creating a chaotic patchwork of enforcement, federal coordination is necessary. And late yesterday afternoon, according to documents obtained by Reuters and confirmed by sources in the U.S. Attorney's Office for the Southern District of New York, Judge Lewis Kaplan, who presided over the E. Jean Carroll trial, agreed. He issued an order authorizing the U.S. Marshals Service to enforce the Carroll judgment by identifying, inventorying, and if necessary, seizing Trump assets located anywhere in the United States. Other creditors immediately filed motions to join the enforcement action. The floodgates are open. For the first time in American history, federal law enforcement is preparing to treat a sitting president's private business empire like any other judgment debtor's assets. And the president cannot stop it because he is the defendant. In this emergency briefing, we are going to explain exactly how federal marshals enforce civil judgments. We are going to identify which assets are now vulnerable. We are going to analyze the constitutional collision that is about to happen when federal agents appointed by the judiciary try to seize property from a president who controls the executive branch. And we are going to answer the question that is paralyzing Washington. What happens if Trump orders federal law enforcement not to enforce federal court orders against him? Buckle up. The government is about to go to war with itself. To understand how we got here, we need to understand the specific legal mechanism that just activated. When you win a civil judgment in court, the court issues a piece of paper that says the defendant owes you money. But that piece of paper does not automatically turn into cash. You have to collect it. In most cases, collection means identifying the debtor's assets, bank accounts, real property, vehicles, and asking the court to authorize seizure. The court issues a writ of execution, which is essentially a permission slip for law enforcement to take stuff and sell it to pay the debt. In state court, the local sheriff handles this. In federal court, the U.S. Marshals Service handles it. The marshals are not just bodyguards for judges and witnesses. They are the enforcement arm of the federal judiciary. They serve warrants, transport prisoners, and execute court orders, including asset seizures. What makes the situation unprecedented is that the marshals are now being asked to enforce judgments against a sitting president's property. Normally, if a marshal shows up to seize property, the owner can complain, but the law is clear. The judgment is valid. The court has authorized the seizure, comply or face contempt. But what happens when the owner is the president of the United States? What happens when the property is protected by the Secret Service, which reports to the Department of Homeland Security, which ultimately reports to the president? We are about to find out. According to sources who spoke to Politico on condition of anonymity, The U.S. Marshals Service has been conducting quiet legal research for the past 10 days on the question of presidential asset enforcement. They have consulted with the Office of Legal Counsel, the Justice Department's internal law firm. They have reviewed historical precedent going back to the Civil War. And they have concluded that there is no constitutional immunity for a president's private assets from civil judgment enforcement. The president is immune from civil damages for official acts performed while in office, but the judgments against Trump relate to conduct before he took office or to personal business dealings unrelated to presidential duties. Therefore, according to the Marshals' legal analysis, the judgments are enforceable regardless of Trump's current position. The question is whether the analysis matters when the president can simply order his subordinates not to cooperate. Now, let us get specific about what the Marshals are preparing to do and why the logistics are so complex. The U.S. Marshals Service has divided the enforcement operation into 3 phases, according to an internal planning document that was leaked to CNN and verified by multiple law enforcement sources. Phase 1 is asset identification. Marshal deputies, working with forensic accountants hired by the judgment creditors, are compiling a comprehensive inventory of Trump Organization assets. This includes real property such as office buildings, golf courses, and estates. It includes personal property such as aircraft, vehicles, artwork, and furniture. It includes intangible property such as trademarks, licensing agreements, and intellectual property rights to the Trump name. And it includes financial accounts, bank deposits, brokerage accounts, and receivables from tenants and licensees. The goal of Phase 1 is to know exactly what exists and where it is located. This phase is nearly complete, according to sources. The creditors have had investigators working on this for months, and the information has been compiled into a database. Phase 2 is notification and seizure. Starting Monday, February the 2nd, Marshal deputies will begin serving notice on specific Trump properties. The notice is a legal document that informs the current occupants and managers that the property is subject to a federal court order and that control is being transferred to a court-appointed custodian. This is not a physical takeover in most cases. It is a legal takeover. The Marshals post notice. They photograph the property. They change the locks if necessary. And they inform everyone involved that the property now belongs to the judgment creditors, not to Donald Trump. Phase 3 is liquidation. If Trump does not pay the judgments within a specified period, typically 90 days, the custodian is authorized to sell the assets at public auction. The proceeds go first to pay the costs of enforcement, then to satisfy the judgments in order of priority. Anything left over goes back to Trump. But based on the amount of the judgments relative to the likely sale value of the assets, there probably will not be anything left over. Trump could lose everything. The Marshals understand that this is politically explosive. They understand that they are walking into a minefield. But according to sources within the service, the leadership has made clear that they will follow the court's orders. The alternative, refusing to enforce a federal judgment because the defendant is politically powerful, would destroy the legitimacy of the entire judicial system. So they are moving forward carefully but deliberately. Let us talk about the specific assets that are now in the crosshairs, because some properties are more vulnerable than others. Target 1 is the Trump National Golf Club in Bedminster, New Jersey. This is a 560-acre property that Trump purchased in 2002. It includes 2 golf courses, a mansion that Trump uses as a summer residence, and extensive grounds. The property is valuable, estimated by real estate analysts at between $150 million and $200 million. But more importantly, it is not Trump's primary residence, which means it does not qualify for homestead exemptions that protect primary residences from creditors in many states. The Marshals can seize it. Bedminster is also symbolic. This is where Trump spent many weekends during his first presidency. This is where he hosted foreign dignitaries and conducted informal diplomacy on the golf course. Losing it would be a psychological blow, not just a financial loss. Target 2 is the Boeing 757 private jet, the plane Trump used during his campaigns, and that has become synonymous with his brand. The plane is registered to a Trump Organization subsidiary. Its estimated value is approximately $25 to $40 million, depending on condition and maintenance. Aircraft are relatively easy to seize because they are registered with the Federal Aviation Administration, and the FAA can ground a plane if a court order requires it. The Marshals can serve notice, and the plane cannot take off until the dispute is resolved. Imagine the optics. The president's personal jet, the same plane he uses to fly to campaign rallies, grounded by federal court order because he owes money to a woman he defamed. It is humiliating, and it is entirely legal. Target 3 is the commercial licensing agreements. Trump does not own most of the buildings that bear his name. He licenses the Trump brand to developers who pay him fees for the right to use the name. These licensing agreements generate millions of dollars per year in passive income. They are assets. They can be seized. A court can order that all future royalty payments be redirected from Trump to the judgment creditors until the debt is paid. This is particularly devastating because it is invisible to the public but catastrophic to Trump's cash flow. He loses income without losing the property itself, which means he still has to pay the expenses of maintaining his empire while receiving no revenue. Target 4 is the Mar-a-Lago club memberships and operating revenue. Mar-a-Lago is Trump's primary residence, which complicates seizure. But it is also a private club that charges membership fees and hosts events. That business income is not protected by homestead exemptions. The Marshals can appoint a receiver to take control of the club's finances, collect the membership dues and event fees, and redirect that cash flow to the creditors. Trump would still live there, but he would not control the business. He would be a tenant in his own club, watching someone else collect the money from his members. This is the blueprint for financial humiliation. Here is where the situation becomes a constitutional crisis. The U.S. Marshals Service is part of the Department of Justice, which is part of the executive branch. The president is the head of the executive branch. Trump could theoretically order the attorney general to instruct the marshals not to enforce the court orders. This would be obstruction of justice, but Trump has never been constrained by legal niceties when his survival is at stake. According to sources who spoke to The Atlantic, this scenario has been war-gamed inside the White House counsel's office. The conclusion is that any direct order to federal law enforcement to ignore a court order would constitute an impeachable offense and would likely result in mass resignations within the Justice Department. The Attorney General would resign, the deputy would resign, career prosecutors would resign in protest. The institutional damage would be catastrophic. But there is a softer version of obstruction that Trump might attempt. Instead of directly ordering the marshals not to act, he could order the Secret Service to deny them access to the properties, citing security concerns. The Secret Service has a statutory duty to protect the president. If they determine that allowing federal marshals onto a property poses a security risk, they can refuse access. This creates a standoff. The marshals have a court order. The Secret Service has a security mandate. Who wins? According to legal experts interviewed by the Washington Post, the answer is unclear. There is no precedent for this situation. One possible resolution is that the marshals and the Secret Service negotiate a protocol. The marshals can serve notice and post documents, but they cannot physically enter areas where the president is present. The seizure happens on paper, even if physical access is delayed. But Trump could exploit the ambiguity to delay enforcement for weeks or months, filing motion after motion claiming that the marshals are endangering presidential security. The courts would eventually rule against him, but the delay achieves his real goal, which is to run out the clock. If he can delay until after the midterms, and if Republicans somehow hold Congress, he might be able to negotiate a political solution. But that requires everything going right for him. And right now, nothing is going right. Let us discuss the human element, because this enforcement action is not being carried out by robots. It is being carried out by career law enforcement officers who are watching their institution being weaponized in a political battle. According to interviews conducted by ProPublica with current and former marshals, the mood within the service is one of grim determination mixed with anxiety. These are men and women who took an oath to enforce the law without fear or favor. They have served warrants on drug kingpins, domestic terrorists, and organized crime bosses, but they have never served an enforcement action on a sitting president. Some marshals reportedly view this as their duty, their finest moment. If they can enforce the law even against the most powerful person in the country, it proves that the system works. But others are worried about the political blowback. They worry that they will be demonized by Trump supporters as deep state operatives. They worry about threats to their families. They worry that this will be used as a pretext to gut the Marshals Service in future budget negotiations. The leadership is trying to keep morale up. They are emphasizing that this is not political. This is legal. The courts have spoken. The marshals execute. But everyone knows that executing this order will have political consequences, whether they want it to or not. Some career marshals are reportedly considering resignation rather than participate in the operation. Others are volunteering to be on the front lines because they believe this is exactly what they signed up for. The institution is being stress tested in real time. Now, let us analyze the financial mechanics of what happens after seizure, because this is where Trump's empire actually dies. Seizure is not the same as liquidation. Seizure means the marshals take control. Liquidation means they sell the assets. Between seizure and liquidation, there is a period where the assets are held by a court-appointed custodian who must maintain them, pay the expenses, and prepare them for sale. This period is expensive. Bedminster, for example, requires groundskeepers, maintenance staff, utilities, insurance, and property taxes. Those costs are approximately $200,000 per month, according to estimates based on similar properties. If the property is not generating revenue because it is no longer operating as a business, the custodian has to pay those costs out of a reserve fund provided by the court or by borrowing against the property's value. This increases the debt and decreases the net proceeds available to the judgment creditors. Trump knows this. His strategy will be to make the properties as expensive and difficult to maintain as possible, hoping that the creditors give up and settle for a reduced payment rather than go through the costly liquidation process. He might order his staff to quit, leaving the properties unstaffed and forcing the custodian to hire new people. He might cancel insurance policies, forcing the custodian to obtain expensive replacement coverage. He might dispute utility bills and property tax assessments, creating administrative chaos that costs time and money. This is scorched earth. If Trump cannot keep the properties, he will make sure they are worthless to everyone else. But the creditors anticipated this. According to court filings reviewed by Bloomberg Law, the judgment creditors have agreed to advance funds to cover maintenance costs during the liquidation period. They have hired property management companies that specialize in distressed asset operations. They are prepared for a long, ugly fight, and they have the law on their side. Every delay tactic Trump employs can be challenged in court. Every act of sabotage can be prosecuted as contempt. The system is slow, but it is relentless. Let us talk about the international reaction, because what is happening to Trump is being watched very closely by foreign governments, and their conclusions will shape America's global standing for years. In democratic countries, the reaction is cautiously positive. European diplomats, speaking anonymously to the Financial Times, have expressed relief that the American legal system appears to be functioning. They see the enforcement action as proof that rule of law still exists in the United States, even when applied to the most powerful individual. This strengthens America's moral authority to criticize autocratic regimes that place their leaders above the law. But in authoritarian countries, the reaction is more complex. Chinese state media is running stories suggesting that the asset seizures prove that American democracy is chaotic and unstable. The narrative is that the United States cannot even protect its own president from legal harassment. So how can it project power abroad? Russian media is taking a different angle, suggesting that the enforcement action is evidence of a deep state coup, a shadowy elite using the judiciary to destroy a leader who threatened their control. This narrative is designed to undermine confidence in democratic institutions, not just in America, but globally. If the United States cannot maintain order within its own government, why should other countries trust American leadership? In the Middle East, the reaction is pragmatic. Gulf states that have invested heavily in Trump properties and have maintained close ties with his administration are reportedly scrambling to distance themselves from potential legal liability. If Trump assets are being seized, investors who partnered with him might also face scrutiny. According to reporting by the Wall Street Journal, the Saudi Public Investment Fund has quietly put on hold several planned investments in Trump-branded developments until the legal situation clarifies. This is a polite way of saying they are abandoning Trump. The reputational damage is too high, the financial risk is too great, and the strategic value of maintaining the relationship is diminishing as Trump's presidency weakens. Let us examine the nightmare scenario that is now being discussed in classified briefings at the Pentagon. The scenario goes like this. Federal marshals attempt to serve notice at Mar-a-Lago. The Secret Service, acting on Trump's orders, refuses to allow them access. The marshals obtain a court order compelling access. The Secret Service still refuses, citing presidential security. The judge holds the Secret Service director in contempt. The director resigns. Trump appoints a loyalist who doubles down on the refusal. The standoff escalates. The marshals request assistance from other federal law enforcement agencies. The FBI is called in. But the FBI also reports to the executive branch. Trump orders the FBI not to assist the marshals. The FBI leadership is divided. Some agents follow the president's orders. Others follow the court's orders. We now have federal agents on both sides of a barricade at Mar-a-Lago. One group trying to enforce a court order. Another group trying to protect the president. Both believe they are following the law. This is the opening scene of a constitutional collapse. At this point, the military starts receiving calls from members of Congress asking whether the armed forces would intervene to enforce the court order. The chairman of the Joint Chiefs of Staff makes clear that the military does not get involved in domestic law enforcement disputes. But privately, according to sources who spoke to Defense One, senior military leaders are terrified that they will be asked to choose sides. If Trump orders the military to protect his properties from federal law enforcement, what do? If Congress passes a resolution calling for military enforcement of court orders, what do? The military is supposed to be apolitical. But there is no apolitical position in a fight between the executive and judicial branches. Any action or inaction is a choice. This scenario sounds extreme, but it is not far-fetched. We are 2 steps away from it right now. The Marshals are preparing to act. Trump has already demonstrated a willingness to defy courts. The only question is how far he is willing to go. Now let us talk about the political calculation that Trump is making, because he is not just fighting for his assets. He is fighting for his identity and his future. If Trump loses his properties, if he is publicly humiliated by having federal marshals seize his golf courses and his plane, he loses the aura of success that has sustained his political career. Trump's brand has always been winning. He is the billionaire. He is the deal maker. He is the guy who turns everything he touches into gold. But if the public sees him as a debtor, as someone who cannot pay his bills, as someone whose assets are being auctioned off to satisfy judgments, that brand collapses. And without the brand, Trump loses his hold on the Republican Party. The polls already show this happening. According to data from a Reuters Ipsos poll conducted between January 27th and January 29th, Trump's favorable rating among Republicans has dropped to 58%, down from 71% in December. This is a catastrophic decline in just 6 weeks. The decline is driven by suburban Republicans and college-educated conservatives who are exhausted by the chaos. They voted for Trump in 2024 because they wanted change, but they did not want this kind of change. They wanted competent governance, not constitutional crises. Trump's advisors are telling him that he needs to settle the judgments, pay the money, and move on. But Trump cannot accept that advice because it requires admitting defeat. And Trump has built his entire psychological identity around never admitting defeat. So instead, he is doubling down. He is attacking the judges. He is attacking the creditors. He is attacking the marshals. He is framing this as a political persecution, a witch hunt, a conspiracy. The strategy has worked before. It energizes the base. It generates donations. But the problem is that the base is shrinking. Every new crisis peels away another layer of support. The hardcore MAGA loyalists will never leave, but they are not enough to win elections. Trump needs the moderates, the independents, the suburban voters, and he is losing them. Let us consider the legal theory that Trump's lawyers are preparing to deploy as a last-ditch defense. According to sources who spoke to Politico, Trump's legal team is drafting a motion arguing that the enforcement of civil judgments against a sitting president violates the separation of powers doctrine. The argument goes like this: the president is the head of the executive branch. His ability to perform his constitutional duties requires focus and stability. Forcing him to defend against asset seizures, to negotiate with creditors, and to manage financial crises creates a distraction that impairs his ability to govern. Therefore, civil judgment enforcement must be stayed until he leaves office. This is similar to the argument made in Clinton versus Jones, where President Clinton tried to delay a civil lawsuit until after his presidency. The Supreme Court rejected that argument, ruling that civil litigation could proceed against a sitting president. But Trump's lawyers will argue that this is different. Clinton versus Jones dealt with the litigation itself, the trial. This situation deals with post-judgment enforcement, the seizure of assets. The lawyers will argue that there is a meaningful distinction. Requiring a president to sit for depositions and testify at trial is one thing. Seizing his property and forcing him to manage a financial collapse is another. The legal theory is weak, but it is not frivolous. There is a colorable argument that the distraction caused by asset seizures rises to a level that impairs presidential function. The problem for Trump is timing. Even if his lawyers file this motion, even if a sympathetic judge grants a temporary stay, the appeals process takes months. And in the meantime, the creditors are not sitting still. They are moving to seize assets in multiple jurisdictions. Trump cannot stop all of them at once. It is like plugging holes in a dam while the water level keeps rising. Eventually, something breaks. Let us discuss the role of Congress, because the legislative branch has been conspicuously silent during this crisis, but that silence cannot last. Democratic members of Congress are watching the enforcement action with a mixture of satisfaction and concern. Satisfaction because they believe Trump is finally being held accountable for decades of fraud and misconduct. Concern because they understand that the spectacle of federal marshals seizing a president's property is damaging to the institution of the presidency, even if this particular president deserves it. According to sources who spoke to The Hill, House Democratic leadership is quietly preparing oversight hearings to examine the Marshal Service's handling of the enforcement action. The goal is to ensure that everything is done by the book, that no corners are cut, and that Trump cannot claim he was treated unfairly. Republicans in Congress are in a much more difficult position. The MAGA wing, led by representatives like Marjorie Taylor Greene and Matt Gaetz, is demanding that Congress intervene to protect Trump. They want hearings attacking the judges. They want legislation stripping funding from the Marshals Service. They want impeachment articles filed against Judge Kaplan. But establishment Republicans, led by senators like Mitch McConnell and John Thune, understand that defending Trump on this issue is political suicide.